what the parents did in terms of the agony that this must have caused them. However, I once again would reiterate that while I agree with what's happening with the recommendation today, it is totally, I also happen to agree with his agreement that it should be a delayed imposition of an adult and not a straight juvenile, because quite frankly, 8 years, as I stand here before the court, 8 years would be the max this court, if you did a juvenile sentence, the max this court could hold him. Quite frankly, 8 years for a first-degree murder is insufficient. Having said that, I'm going to tell you that's my personal view on it. It's a first-degree murder. Connor's never coming home. He can get released when he's 21. I don't think we protect society that way. Therefore, once again, for that reason, we do need, I guess I'm going to say the juvenile system might not give the proper punishment. Even if you kept him in an institutional placement for 8 or 9 years, that might not be sufficient punishment. He might not be rehabilitated. And everyone deserves, as does society, and quite frankly, as a prosecutor, I have to look at what's best to society as well. They need to have a message that you don't commit a first-degree murder and then maybe get to walk 8 years later, unless you really, really have shown the court that you never would do something like this and that you're completely rehabilitated. So therefore, I'm asking the court, just please do not preclude the option for yourself in the future of that, because 8 years just quite simply just might not be enough. Thank you.
Thank you, Your Honor.
Obviously, the court's aware of everything that's gone on here in the trial. You're as aware of all the facts that have happened as frankly, the counsel are at this point. This is a result of, this is the potential catastrophic result of lifelong abuse. This is why abuse is such a problem in our society. This is what could happen. You couple that with...
Yeah, in the best interest of Jamarion be served by a juvenile sentence.
Jamarion, I want to give you an opportunity to speak today and say as much or as little as you like.
I'm sorry for my actions. I have been going through lots of things during that month. Every night I have cried for all the pain I have caused throughout the whole process. I have had days without eating because of what had happened. If I could go back, I would start myself. I now realize the nightmare that you and I have to live with. I don't show any emotion because if I do, I would not stop crying. After the day I was convicted, I did not know how to handle it. All I did was tell myself it was nothing else. It was all over and I could never live a normal life. People think I'm crazy, but they don't know what. They do not know me. If I could go back, I would take all the pain and stress rather than taking life. And I really don't understand none of this. I just try to, but I really don't and do not like what I did, and neither do you. And I know what I did was wrong. I just do not understand why I did it. I made a terrible mistake. I just want you to know that I am sorry for all the pain you have been going through. And when I get older, I will help kids not to make the mistake I made and help them become a better person in life so they will not have to suffer the abuse I had to suffer on that day. I was so scared, I was afraid. My stepfather, I was afraid of my stepfather. I wanted to die because I thought there was no way out. I now know hurting someone was not the right answer. I have been talking to a pastor and asked him to talk to the kids in the detention center so he can help them how he was helping me. I'm sorry for what I did. I just wanted you to know that. I just wanted you to know that.
So ask the boy, I'm trying to have you have today to change your motion that I hope I will do this well. The court has considered the factors that I've already reviewed as the law requires. The court is also mindful of other circumstances in the case. I am also the judge who is in the Lawhorn neglect case, and I have extensive knowledge of the family from which Jamarion comes. He has been raised in a home with a lengthy history of neglect and physical abuse. His mother had her parental rights terminated over 2 previous children a number of years ago for physical abuse. Child Protective Services were involved with the family in August and September of 2005 and as recently as May and June of 2013. In 2013, Ms. Lawhorn and her longtime partner, Bernard Harold, were substantiated for physical abuse of Jamarion. He was beaten with an extension cord so brutally as to leave permanent scarring on his legs. Then he was moved to his father's home in New York, where he was beaten by his alcoholic paternal grandmother before being returned to Grand Rapids and his mother and Mr. Harold's home. And I must say that the court was not entirely persuaded by Ms. Lawhorn's or Mr. Harold's trial testimony that neither had used physical punishment on Jamarion since 2013. While no child should be subjected to neglect and physical abuse like Jamarion was, the court understands and appreciates that a troubled upbringing is neither a legal defense to murder nor an excuse for violent behavior. But Jamarion was 12 years old when he committed this killing, and it would be naive to conclude that his life experience had nothing to do with his scheme of killing someone so that he would be arrested and executed. The U.S. Supreme Court, Miller v. Alabama, which is sort of the most recent case that the court has decided, a case where a 14-year-old child from Alabama had killed someone. That's someone who was 2 years older than Jamarion at the time he committed this crime. Explained in some detail the reason why we as a society treat juvenile killers differently than adult killers. The court relied on 3 significant gaps between juveniles and adults. First, children have a lack of maturity and an underdeveloped sense of responsibility, leading to recklessness, impulsivity, and heedless risk-taking. Second, children are more vulnerable to negative influences and outside pressures, including from their family and peers. They have limited control over their own environment and lack the ability to extricate themselves from horrific crime-producing settings. And third, a child's character is not as well formed as an adult's. His traits are less fixed and his actions less likely to be evidence of irretrievable depravity. The court further noted that as science has progressed, the science continues to show fundamental differences between juvenile and adult brains. For example, in parts of the brain involved in behavior control. There is a difference between a 12-year-old and an adult making a horrible decision like this. The case is a tragedy all the way around for any of us who have been involved in it. The 12-year-old child brutally murdered at random a 9-year-old defenseless child, leaving behind a family that aches over the loss of a child deprived of the ability to grow up, to fall in love, and to make life choices for himself. And the 12-year-old killer who did not choose to be raised in an abusive and neglectful home is now faced with coming to terms with the pain he has inflicted, losing his freedom, and losing the ability to lead a normal childhood and adolescence. It is the court's decision to impose a blended sentence in this case. That is a disposition that delays the imposition of a prison of sentence under MCL 712.8.18(1)M. The court places Jamarion on probation under MCL 712.8.18 sub 1 sub B with appropriate conditions. Those conditions include being committed to the Muskegon River Youth Home under MCL 712.8.18(1) sub D. The court reserves and delays the imposition of a prison sentence unless and until a request is made to impose a sentence of imprisonment. As I understand the positions of the parties, both parties agree that it is appropriate to simply wait to determine an appropriate sentence if and when the court is asked to impose such a sentence. I do want to remind everyone, and I'll of course remind Jamarion at review hearings, that violations of probation under the law can result in the revocation of the probation and the imposition of the adult prison sentence. It is critical that Jamarion make his best efforts at the Muskegon River Youth Home to take advantage of the services, to abide by the rules, and to prove to all of us and to himself that he is capable of turning his life around. I believe in redemption. I'm not willing to give that up on a 13-year-old boy at this point. Jamarion, you have the right to appeal your conviction to the Michigan Court of Appeals. The court will appoint you an attorney if you cannot afford one. We are about to provide you with a form to request a court-appointed attorney. You must complete the form and return it to the court within 42 days, or your request will be denied. Ms. Retzkevich, I'd ask if you would kindly make sure that Jamarion completes the form now, so that we do not run any risk of him waiving his appellate rights. Following their meeting with Jamarion after today's hearing, the court will discharge both Mr. Buckaloo and Ms. Retzkevich from their respective roles as defense counsel and guardian ad litem for Jamarion. It has been a difficult case. The court thanks each of them for their service under difficult circumstances. The court will simply appoint a new counsel from our assignment panel to handle the review hearings in the future. Ms. Seidel, is there anything else you would like to bring before the court while we're here? Mr. Buckaloo?
Nothing.
Ms. Retzkevich?
No, Your Honor.
Jamarion, good luck. I'll see you at review hearings in about 6 months. I wish you the very best of luck, and thank you all very much.